Is it true that an LLC must register and pay filing fees in all 50 states? The assumption here is that if the LLC is selling online to people in all 50 states, does it need to register in all 50 states? You might say, well, what does the registration look like? Let's say you have an LLC in California. If you're doing business in New York, New Jersey, and every other state, the states require that you register there. So the simple answer is yes. By law, if you are doing business in another state, you must register there. That's what the law of those states say. But practically speaking, that's expensive because not only do you have to register there, but usually you have to have a physical address where you can be served a lawsuit there. So now you're paying for a registered agent service. The second part of this question is it a one-time fee or do you have to keep doing it? In most states, you have to keep renewing it every year. That also means paying registered agent fees every year in all these states. Well, as you can imagine, this is extraordinarily expensive for a small business. So what are you going to do about it? It's fine if you're Amazon. You can afford to have these registered agent offices and annual renewals in every state. But most businesses simply can't afford it. So what they often do is either don't file to do business in any state except their own where they already have the LLC registered, or they pick one or two states where they may have a lot of sales occurring. Well, you might say, well, what's the risk of not registering your business in 50 states? Because it sounds like I can't afford it. Here's the risk. If somebody who you sell to in a state where you haven't registered goes to sue you, you probably won't know about the lawsuit. Because if you're sued in, let's say, New York, and you don't have a registered office there, you don't have a registration with New York, under New York law, the person suing you can serve the notice on the government there, serve the summons and complaint. And there's a specific process in the statute that they have to follow. But there's a very reasonable chance you will never get a copy of these documents. And so you don't know about the lawsuit, which means you can't show up. And if you don't show up at that lawsuit, they win by default. It's called a default judgment. So now they have a judgment against you in New York. Let's say they sued you for $50,000 and the judge granted that. So now you have a $50,000 judgment against you in New York. What do they do with that? Well, they have a couple options. First, they can garnish and levy funds in a national bank. So if they go after like Huntington, Wells Fargo, or one of these big national banks, they can levy your funds because they have an office in New York. New York judgment is applicable to a bank with an office in New York. Now they can freeze the funds in your bank account. Another option is they transfer that judgment to the state where you live, docket it there, they get it filed there, and under the United States Constitution's full faith and credit clause, the judgment in New York is given full faith and credit in your state. So the courts must accept that judgment and docket it. Now they have a judgment in your state. Again, you may not even know about this, but now they can go freeze assets, lien them, levy them, garnish them, have a sheriff's sale, whatever is allowed by state law in that state. So I've had this happen with clients. I had a client who reached out to me and said, hey, somebody just froze a lot of money in our bank account. And apparently it has to do with a Minnesota lawsuit from a long time ago. And sure enough, I looked, and they had not registered in Minnesota, but they were doing business in Minnesota. They were sued in Minnesota. They didn't know about it. They didn't show up. They lost. That judgment came, and they now froze money in the bank account. There is a process to try to undo these judgments, but in general, they're very difficult to do. And in this case, the court refused to undo the judgment. And so as a result, because this business did not register to do business in Minnesota, they owed a large amount of money to somebody who'd sued them. They had a good argument for why they didn't owe the money. They potentially could have won the case, but it was too late. That is a worst case scenario. Practically speaking, most businesses only register to do business in the state where they have significant sales. You can also have an arbitration clause in there, which requires that they serve you an arbitration, so that increases the odds that you are not going to get hit with a lawsuit in that state, because they are required under the contract to arbitrate with you instead of sue you. So, are you required by law to register in any state where you have sales, or business, or employees, or a presence? You absolutely are. Each state requires that. I'm Aaron Hall. I'm an attorney for business owners and entrepreneurs. I do this educational channel to help you spot issues to discuss with your attorney, to help you identify ways to avoid problems. But keep in mind, it's an educational channel. This is not a replacement for using an attorney who understands the law in your state, in your jurisdiction, and can take the time to understand your particular goals, concerns, and exceptions that might apply to you. I'd love for you to get the exclusive free resource that we make available to subscribers. It's a list of common legal problems and how to avoid them, and then educational videos talking about how to avoid those problems in your company and set your company up for success. You can get that at aaronhall.com/free. Enter your email address, and we will start sending you that information by email. If you have other questions, feel free to continue to add them here. I will use those questions to answer in a future live Q&A. It was great being with you today. I look forward to seeing you again on the next live session.